Hi, I'm Shannon Gunn Emery, and today we are going to be legalizing sex work. The way we're going to do that is to first look at the legislation. That may sound boring, but it really isn't. And then to look at how those laws play out in real life. And do you know how we're going to do that? I'm going to have you hear, through my voice, but their words, the actual experiences of sex workers. If you had asked me 5 years ago if this were a subject that I wanted to cover on a podcast, if I had been podcasting at the time, I would have said no. I wouldn't have seen what the point was. I didn't have any strong feelings about it. Well, that all changed for me during one trial. And as we go through this podcast, my hope is that your opinion may change as well. Let's get started. Now, I know I'm running the risk of having you guys stop listening and go do something else when we start on the legislation. Trust me, you need that little bit of background to really understand what happened to these 4 women and the 2 men who were hired to help 2 of them. One more housekeeping item that I often don't include, but here I want to make it clear that I am not advocating any type of lifestyle. I'm not suggesting that people get into this kind of work, and I am not inducing, encouraging, or influencing the movements of anyone, and you'll understand why I say that later. Plus, this is not legal advice. And actually, I would strongly recommend someone get independent legal advice before engaging in any activities related to this subject. Okay, now let's get started. After we do our little run-through of the legislation, you'll be hearing from Diane, Carol, Lori, and Terry. As you know, the names have been changed to protect the innocent and the not-so-innocent. In 2013, the Supreme Court of Canada handed down the decision of Bedford. You might have heard about it. Here's the Reader's Digest version. The Supreme Court decided that certain laws governing sex work were unconstitutional. However, the court suspended its declaration of invalidity for 1 year. That was to give the federal government time to come up with better laws so that there wasn't just a void in place when they struck down the old ones. So for 1 whole year, or at least a few months just before the end of the full year, because it sounds like the government just shoved this legislation in at the very last second, they were supposed to be grappling with a philosophical dilemma too. Should they try to abolish sex work, or should they try to regulate it? They came squarely down on abolish. Get rid of it. We don't want it at all, and we're going to criminalize everything associated with it so that people won't engage in it, because criminalizing things, of course, stops people from doing it. That's why when we started criminalizing theft or impaired driving or assaults, they just stopped happening. But the Supreme Court of Canada had forced the government to face another philosophical dilemma. Who are they actually trying to protect with these laws? Criminal laws are usually put in place to protect someone. Now, you may be thinking, dear listener, well, isn't it obvious? They're trying to protect sex workers, the women who engage in this. The Ontario Court of Appeal, in a case called NS, says, you're wrong. No, they weren't trying to protect sex workers at all. Now, it is true that Peter MacKay in Hansard had said that they were trying to protect communities at large. The government said that too in its technical paper. They were trying to protect you and me and others. Did you even realize how much sex work had impacted your life? You might not have thought about it, but thank goodness the government was there to protect you. And while the Ontario Court of Appeal will not agree with me, the federal government did also say they were trying to protect sex workers. Problem is, as we will see, the objective of protecting sex workers and the objective of abolishing sex work through criminalization come into conflict with each other in a rather spectacular way. So did the government get it right? I don't think so. But this will be an issue that the Supreme Court of Canada will have to grapple with. Again. So now let's take a look at what the laws actually say. So in direct response to the Supreme Court of Canada's decision in Bedford, in 2014, the government introduced new laws, specifically sections 286.1 to 286.4 of the Criminal Code. Let's go through those quickly together. First, we turn our legal eyes to section 286.1. That makes it an offense to communicate with someone or to obtain from that person sexual services for consideration. That means for money. I'm going to jump out of order just once and just for a moment to 286.5, because 286.5 sub 1 and sub 2 purport to give immunity to sex workers who are providing their own sexual services. So a person who is providing the sexual services, as long as it's on their own and not through a third party, should not, in theory, be prosecuted. There is a great debate now raging whether buying and selling sex is legal or not. Has Parliament just, again, criminalized parts of it, or have they made it illegal and just carved out a bit of immunity for those providing their own sexual services? We will eventually see what the courts have to say about that. Okay, back to our review of the legislation. Behind door number 2 is section 286.2, the material benefits section. Now, if this one seems oddly familiar, it's because it is. It is living off the avails dressed up in different language. The government refers to that as modernizing that section. This one says, if you receive a financial or other material benefit, that is not defined, by the way, knowing that it was derived directly or indirectly from the commission of an offense pursuant to section 286.1, you remember what that is, we just went through it. The obtaining or communicating with another person for sexual services for consideration, well, you've committed an offense. Now you may be saying, well, that kind of makes sense. Listen to this part, because this could affect you or someone you care about. And before you shake your head, dear listener, thinking, oh, no, I have nothing to do with sex work ever, this does not affect me at all, just wait. Section 286.2 sub 3 presumes that a person who lives with or is habitually in the company of a sex worker has received a material benefit. Just think about that for a moment. Habitually in the company of a sex worker? So, like, hanging around with a sex worker would mean that you have been presumed to have received a material benefit. I can't believe it, but I can see you shaking your head again, thinking, well, I don't hang out with sex workers. I certainly don't live with them. I don't even know any. Well, you might not know that you do. During this trial that opened my legal eyes, my co-counsel found a witness for us. It was a person who was going through law school and who had a very interesting perspective on this subject. That's Carol that I mentioned earlier. Well, it turns out I already knew Carol. In fact, I consider Carol to be a friend. Carol is a kind, smart, gutsy lady, and we spoke a lot about her legal aspirations. You know where this is heading. Yes, it turns out Carol, a friend that I knew, had actually been a sex worker. I don't like to admit it, but I was kind of surprised. And I think that's because, like most people, sex workers or prostitutes, depending on the language you're using, conjures up a particular image. And my friend Carol did not fit that image. So Section 286.2 sub 3, that presumption that if you hang around with or you live with a sex worker means the law presumes you have committed an offense, I think that section has some problems with it. But it's not the only one. Let's move on. Section 286.2 is the section that just keeps on giving. So we go to Section 286.2 sub 4, where there are exceptions. Phew, you might be thinking, thank goodness there are exceptions. This is a rather draconian law. It sure is. And Section 286.2 sub 4, the exceptions, were really put in place to respond to the Supreme Court of Canada's decision in Bedford. Because the Supreme Court of Canada had been very concerned that sex workers could not employ people to keep them safe. With the old laws, they couldn't hire drivers or bodyguards, for example, who would enhance their security. 286.2 sub 4 was the government's response to that. And it might have been okay if they hadn't added 286.2 sub 5, but we'll get to that in a minute. 286.2 sub 4, here we go. You won't be found guilty of a material benefit if you can fall within the following exceptions. 286.2 sub 4a. If you are in a legitimate living arrangement with the person from whose sexual services the benefit is derived, then you are not guilty of having received a material benefit from the sex work. The government very helpfully explained in its technical paper and elsewhere that these laws do not prevent sex workers from having families. That's why Section 286.2 sub 4 sub a is there, because otherwise it would. No mothers, sisters, brothers, or kids for you, sex workers. Oh, never mind, it's okay, you can have those because the government has permitted it under Section 286.2 sub 4 sub a. I hope you're grateful. Actually, it's all your familial companions that should really be grateful because they're the ones who would otherwise have been criminalized. And the government did not define what is a legitimate living arrangement. I guess we'll find out as people get charged. The next subsection is as clear as mud, but we will figure it out together. Section 286.2 sub 4 sub b. Here we go. You do not receive a material benefit if the benefit was as a result of a legal or moral obligation of the person from whose sexual services the benefit is derived. I know, that makes my head hurt too, but here's my take on it. What I think the government is awkwardly trying to say is that the kid whose sex worker mom does their laundry for them did not receive a material benefit because she had a legal or moral obligation towards that person. Now you may be thinking, well, how is that different from 286.2 sub 4 sub a that we said permitted them to have families? Well, wait, that section was all about legitimate living arrangements. But what if this kid was this hapless 20-year-old who doesn't live with the sex worker mom anymore and who has not the slightest clue how to operate a washing machine? Well, Section 286.2 sub 4 sub b is there for you, Johnny. You're going to be okay even if your sex worker mother does your laundry, makes you a meal, or hands you $20 because you're broke that week. The sex worker's aging mother is also protected by that section when sex worker daughter goes out and gets her groceries that week or pays for her room at the retirement home. So I think Section 286.2 sub 4 sub b protects those towards whom the sex worker is in a position of trust. That person who has received a kindness or any other material benefit, and remember, that term is not defined, will not be guilty of a criminal code offense. At least not this one. Paragraph C in consideration for a service or good that they offer on the same terms and conditions to the general public. All those accountants out there are breathing a huge sigh of relief. Phew! I was doing books for that sex worker, and I was a little bit worried, but boy, Section 286.2 sub 4 sub C really came to my rescue. It really came through for the lawyers, the taxi drivers, all those people who might, knowingly or unknowingly, be helping out a sex worker during their normal course of business, even if it's not related to sex work. Section 286.2 sub 4 sub C certainly sends an interesting message. How to scream, sex workers are pariahs. You shall not touch them. You shall not talk to them. You shall not even admit that they exist. But the government knows that they do exist and that we have to do some things with them, like sell groceries to them, offer them taxi rides to places, or rent or sell them living accommodations. The government was really very anxious to protect those innocent landlords who might rent a space to a sex worker, perhaps not even knowing that they were a sex worker, and find themselves in legal trouble. There's a reason why Diane, one of the sex workers that you'll hear from later, said that it was so important that the escort agency that she first worked for provided her with a reference letter that she could give to a potential landlord, because otherwise she has no way to prove any legitimate employment. Section 286.4 sub 2 sub C protects her landlord, and although it would seem to allow Diane to find a living arrangement, that's only if the landlord saw himself as covered by Section 286.2 sub 4 sub C. Isn't it just easier to say no and save yourself any legal risk at all? One more subsection under Section 286.2 sub 4, it's D. In consideration for a service or good that they do not offer to the general public, are we thinking bodyguard, anybody? But that they offered or provided to the person from whose sexual services the benefit is derived, if they did not counsel or encourage the person to provide sexual services, and the benefit is proportionate to the value of the service or good, then the person giving the service did not receive a material benefit. This one is a long subsection, and so we have to break it down into its composite parts. First, we're talking about a service not offered to the general public, like drug dealing? Not sure. That's number one. And then number two, in providing the service, they should not have counseled or encouraged the person to do sex work. And then finally, we have to have the benefit being proportionate to the value of the service being provided. Okay, so where does that leave us? Is working as a bodyguard a service that's not offered to the general public? Maybe. For now, let's use the example of a bodyguard. So how would that play out? Mr. Bodyguard, do not encourage me and do not counsel me to do anything, but please be my bodyguard and don't charge me anything more than the going rate for bodyguards, which is, I don't know, what would that be? Like a loss prevention officer at Safeway? Isn't there immediately a logical disconnect? I mean, if it's a service not offered to the general public, how will you ever know what would be a reasonable value to place on that? And if you don't know that, well, you risk not being able to take advantage of this exception. Well, those are all the exceptions that you can have, except there are exceptions to the exceptions. And I'm not kidding. Now, you know what? To be fair, some of them make sense. I rather like Section 286.2 sub 5A. It says they don't apply if, for example, the person who is trying to fall into the exception category used, threatened to use, or attempted to use violence, intimidation, or coercion in relation to the person from whose sexual services the benefit is derived. That sounds good. You don't want people who are somehow profiting from the sex work of others to be using violence or coercion in order to get that benefit. And if that is what the section said, it might be a really good thing. But unfortunately, I don't think it does. Think about how that's worded. It doesn't say used violence to make them do it. It just says used violence. So if this is a couple and there is conjugal violence, not to force them into sex work, but just violence, then I think the violent partner has now lost the benefit of any exception. I'm not sure that's what the government intended. So while I think the intention was fairly good, I think that section could have benefited from a bit more legal polish. We'll leave it for now. 286.2 sub 5b. Abused a position of trust, power, or authority in relation to the person from whose sexual services the benefit is derived. Okay, well, that sounds like teachers, parents, maybe workers? It's kind of hard to see, but okay. Let me get a little bit more tricky. 286.2 sub 5c. Provided a drug, alcohol, or any other intoxicating substance to the person from whose sexual services the benefit is derived for the purpose of aiding and abetting that person to offer or provide sexual services for consideration. So if we return to the example of the bodyguard and say the bodyguard realizes that Mr. Sex Worker is having a really bad day and hands him a glass of wine saying, "You can do it." Uh-oh. I think the bodyguard just lost any possibility of benefiting from the exceptions in Section 286.2 sub 4. At one point, Lori, one of the sex workers that I mentioned earlier, had said in her testimony that frankly, it's sometimes really difficult to do this work completely dead cold sober. I can imagine. But before you offer your sex worker friend a beer to help them get through the rest of their evening, think about it. D says engaged in conduct in relation to any person that would constitute an offense under Section 286.3. We'll get to that one in a moment. But not to spoil the surprise, it's procuring, like pimping. Although when we look at the wording of the section, you'll be surprised because it likely doesn't match the image you have in your head of pimping. At least it didn't for me. Finally, the last one, Section 286.2, sub 5e. This section is a doozy. It reads as follows. You don't get the benefit of any exception under Section 286.2, sub 4 if you receive the benefit in the context of a commercial enterprise that offers sexual services for consideration. Isn't that everything? What does that not cover? And basically what the government said is it covers everything except a sex worker providing their own services for consideration. So as long as they're working completely independently without anybody else, or they do say in the technical paper if they're working in a cooperative, but that would be with other sex workers and not with, strictly speaking, third parties, and it's not a commercial enterprise, which means what? They don't plan on making any profit at all. So if they're giving away their sexual services, not a problem. Pro bono, that's okay. But anything else where it's not completely independent and they're relying on others, and the purpose of it is to make money, well, now you don't get any of the benefits of Section 286.2 sub 4. Do you see what I mean when I said that maybe 286.2 sub 4 would have been okay if it hadn't been for 286.2 sub 5? By the way, if you're found guilty of having received a material benefit under Section 286.2 sub 4, 286.4 sub 6 makes it an aggravating factor that you did so in the context of a commercial enterprise. Moving on to door number 3, procuring. Now, when you think procuring sounds a lot like pimping. Does that conjure up an image for you of some big burly guy trying to drag this poor little helpless female against her will into a horrible life of prostitution? Yeah, it kind of did for me too, at least before this trial and before I really looked at this section. Let's look at it together. So, section 286.3 says, everyone who procures a person to offer or provide sexual services for consideration or for the purpose of facilitating an offense under subsection 286.1 sub 1, you remember what that was, recruits, holds, conceals, or harbors a person who offers or provides sexual services for consideration, or exercises control, direction, or influence over the movements of that person is guilty of an indictable offense. So, if you recruit, hold, conceal, or harbor a sex worker, or you exercise control, direction, or influence over the movements of that person, you're guilty of procuring. Are you starting to imagine scenarios where that could be a problem? Well, don't worry. If you can't, Diane, Lori, Carol, and Terry are going to tell you about how these laws work in real life. The last one is advertising. That's section 286.4. And it's the shortest of the sections. It just says, everyone who knowingly advertises an offer to provide sexual services for consideration is guilty of an offense. Short and definitely not sweet. Given the fact that screening is one of the most important tools that sex workers can use to keep themselves safe, and of course screening means communicating with someone, this is arguably the most vicious section that the government put into place when it created the new laws to respond to the Supreme Court of Canada's concerns in Bedford that the sex workers did not have a way of keeping themselves safe. That's it. We did our homework. We know the legal background. Now let's look at what happened with Lori, Terry, Carol, and Diane. Up first, Lori and Terry. Both Lori and Terry were sex workers with an organization that was comprised of 2 bosses, 3 drivers, and about 4 women, including Terry and Lori, who did the sex work. Not all the women were always around, though. They came and went. Lori had worked with the bosses for a number of years before Terry joined. They both lived in another province, and when Terry joined, she immediately was sent to work with Lori in Somewhereville. I think it is fair to say that Lori was more drawn into this due to a romantic relationship she had with one of the bosses. Terry, on the other hand, heard about the work opportunity through a friend and chased down the bosses, actually giving them an ultimatum at the end saying, if you don't hire me, I'm going to go elsewhere. And they did. Terry, who had always had money issues, explained why she decided to do it. It was mainly about the style of life, a luxurious life where I wouldn't have to worry about money, always knowing that I would not want for food, that I would have my rent paid, and that I was going to be able to do whatever I wanted, be spoiled a little. And I knew I had to sell my body and give all my money to them, but in my head at that moment, I thought it was worth it. Terry and Lori lived in separate residences in Somewhereville. Lori lived in her own house because she didn't want to live with everybody else, but everybody else lived in a mansion. When Terry had first moved to Somewhereville, she had been put up in a very nice condo. She said it was very beautiful, but she described the mansion that the whole group, the bosses, the drivers, and the sex workers all lived in, this way. It was very, very, very beautiful. Big, luxurious. Never did I ever think I would live in a house like that, even once in my life. One was already under its spell right from the beginning. It was perched on a man-made lake. It was enormous, classy, and in a very pretty part of town. The women had their own rooms, and very luxurious rooms. The guys had their own rooms, and the drivers had very simple rooms. In fact, one of the drivers was really in the basement with the dog crates, in a space that was really not luxurious. Terry said that she agreed the reason why that driver stayed there was just for the pleasure of being with everyone. So the arrangement was that Lori and Terry would provide sexual services to clients. They would give all of their money to the bosses. The bosses would take that money and keep a good portion for themselves, but they also paid the rent for the 2 places that people were living. They paid the drivers. They paid for the food. They paid for everything with respect to the workers in the organization. There was definitely a hierarchy in this organization. The bosses were at the top. The sex workers were in the middle. The drivers were at the very bottom. At one point, the Crown in our trial put a question to Lori framed as, when you worked for, and she named the drivers, at which point Lori broke in very indignantly saying, I didn't work for client X or client Y. I didn't work for them. They were my drivers. In a similar vein, Terry, when we were looking at the video of the house, agreed that her room looked much nicer, much more sumptuous than the drivers' rooms, but then she added, but they were the drivers. I would have been really jealous if they had something nice and I didn't. It's interesting when you think about this organization. The government would have called it a criminal organization. The police probably would have said the same. I'm not sure what you're thinking, but sometimes Terry, and maybe even Lori, referred to it like a family. In fact, they went on family outings. As a whole group, they would go to restaurants in various cities, they'd go to concerts, they'd go horseback riding, rafting, canoeing, hiking. Terry added that sometimes it didn't cost anything. It was just for the pleasure of being in each other's company. Sometimes it was very pricey. While the bosses had all the money, they doled it out pretty generously. Terry said if she wanted to go shopping and asked for $500 to $1,000, it was always given. With respect to her material needs, Terry agreed every single need was looked after. But being in the group together satisfied more than just material needs. We need each other. These people needed each other. Now let's face it, what Terry and Lori were doing was not the easiest kind of work. Obviously, intimate acts were very often or even normally involved, but not always. Terry testified that sometimes we could be there for 4 hours at a time, doing nothing in our skimpy little outfits, just laughing and being part of the party without necessarily having to do any sexual act. Later, Diane said something very similar. There was a lot of conversation in what Diane did. She said that men wanted to talk and do so knowing that they weren't being judged. But be that as it may, it is still not easy work. And so the emotional component of the group being all together was crucial not only to the happiness of each, but to the success of the organization. For example, the bosses encouraged Terry and Lori to stay sober. The bosses explained that there was less of a security risk if the women had their wits about them. And while there may have been other, less honorable reasons for imposing rules on drug and alcohol consumption, it is difficult to say that it wouldn't be to the women's benefit to stay sober. In addition, the bosses encouraged the sex workers to keep a diary and to let them know what was working for them, what wasn't, what their goals and aspirations were, what their long-term projects were. One of the women, I'll call her Anita, wanted to open a business. And so the bosses did. They opened a cleaning business for her. And actually, Lori and Terry both worked in it occasionally. But Terry admitted they really weren't good cleaning women, and the business didn't last very long. It did reinforce, though, that these bosses were prepared to help these women achieve their goals. One day, Terry's mother came for a visit. Terry's mother knew that Terry was working as an escort. Terry was sure that her mother was worried about her and said this: "She probably thought I wasn't doing well, that I was mistreated, but really, I was living in a $1-point-something million house. My mother had never set foot in a house like that. I wanted her to come and go shopping and profit from the money I was making." Did you just have a flashback to Section 286.2, the material benefits section? Yeah, me too. But the bosses didn't just dole out money when Terry's mother came. The whole group got together and put on a fancy supper at the big house to celebrate her arrival. One of the drivers did most of the cooking. In fact, he was the cook of the house in addition to his other duties. Everybody shared the tasks around the house, or at least they were supposed to. There was a schedule for taking out the garbage, for dusting, for cleaning up after the pets. Yes, they had 2 dogs and 2 parrots. Terry loved in particular one little parrot that she referred to as her baby. Kind of sounds like a family, doesn't it? Their whole little world came crumbling down on Terry's birthday. Instead of going out and buying the $1,000 to $3,000 pair of Louboutin shoes that she had been expecting, the police stormed the house and, with guns drawn, arrested Terry and one of the drivers. 2 of the others had already been arrested, and 2 others were yet to be arrested. While Terry was in police custody, she phoned her mother and was in tears, saying, "I knew it was too good to be true. What do I do now?" The men were charged, the women were not. It was the Crown in our trial who had called Lori and Terry as support for their own case. But you can kind of see how they were helpful to us too. Then it was our turn. We called Carol and Diane. Diane was 41 years old. She had started working in the sex industry about 6 years before. She had started off with an escort agency, but then ended up going out on her own. Diane made $600 an hour as an independent escort. Just so that all those potential clients out there know it, I do not charge $600 an hour. Not even close. Nope, she was making more than most lawyers. Actually, that income allowed Diane to pursue her dream to become a lawyer. When she testified, she was in 3rd-year law school, at a very prestigious law school, I may add. She said that between working at Starbucks and working in the area that she was working in, it was no contest. She could make way more money as an escort in a shorter period of time. So to any of you who are listening and might be thinking, that sounds like a good opportunity. I would encourage you to think back to our legislative lesson. How easy was that to remember? Was all of it crystal clear? Well, for many judges, that is not the case. They have described the legislative framework around sex work as being a legal minefield. So, while I don't give advice on this podcast, I would strongly recommend no, at least not until the law changes. Now, that non-advice, dear listener, is for your benefit and mine. I do not want to be accused of counseling an offense. And as tempting as it may sound, as we have seen from the review of the law, you could get into a lot of trouble. And so could anyone around you or anyone who tries to help you. Diane is exceptionally smart and sophisticated. She can look after herself, and she makes sure she is safe in both the practical sense and the legal sense. But not everybody can do it like Diane does. The Crown very helpfully asked Diane why was she testifying in this case anyway. I loved her answer. Diane said, "I believe that people in power often don't have the chance or refuse to listen to what sex workers have to say. So for me, it was an opportunity to have people in those high positions to listen to a real story from a real sex worker." When asked who these people were who were in the positions of power, Diane, without skipping a beat, said, "The justice hearing this case, the lawyers, everyone in the courtroom." And now, dear listener, you can add yourself to that list. It took a lot of courage for these women to testify. I want their stories to be heard too, by you. I believe that by opening one set of legal eyes at a time, we can make real changes. Carol had a different story. She started out as an exotic dancer, and one time in Otherwareville, she made $15,000 in a week. $15,000 in a week? Well, times 4, my math is not good, but that's $60,000 in a month. Just so you know, the financial eligibility cutoff to get legal aid was $21,000 a year. Carol could make more in 1 month than that worker who can't get legal aid could make in 3 years. So it's not nothing. And just to insert another little bit of law in here, when we did the constitutional challenge, we were arguing under Section 7, which says that everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. But many will argue that that does not cover economic interests. Well, we argued that it should, especially when you've got that much of an economic interest on the other side. Really. Let's think really hard about it before we definitively shut the door on employment that could net someone $600 an hour or $15,000 in a week. Carol's story demonstrates very well how much of an impact that can have on the direction your life takes. Carol was also a law student, 2nd year, also at a very good law school. But she definitely was not born with a silver spoon in her mouth. Carol left home at an early age. She didn't even finish high school. She had children when she was very young. She was also Indigenous. Carol's grandmother had first-hand experience in residential schools. So at many times in her life, it might have seemed that poverty was her destiny. But no. Sex work was a very lucrative way for this young mother to take herself out of the line of poverty and into one of those positions of power that Diane was talking about. Carol is quite open about her past in sex work. Diane is not. And I understand that. They both spoke eloquently about the stigma attached to sex work. There are so many stereotypes around what a pimp or a sex worker sounds like, looks like, acts like, and many more stereotypes about the relationship between those two. And just like with any other stereotype, there are going to be some characters in real life who fit those descriptions. But just like other stereotypes again, there will be many others who do not. You've been introduced to some of those non-stereotypical people today. No one coerced Terry, Diane, or Carol into that line of work. To be honest, I'm not sure we could say the same for Lori. Diane was still doing sex work. Carol had stopped for a number of reasons. But looking back, neither regretted their choice. There is no doubt that sex work can be dangerous. As Diane said, all kinds of work can be dangerous. She gave the examples of the military or people who work with heavy equipment. Are the stories that I've told you today real-life stories? Are they typical of sex workers? Not necessarily. Our expert said no, but they were not one-off situations either. Our expert knew of other situations where sex workers made a very good living without being exploited. Yes, some sex workers may be coerced into that kind of work, but others choose it. Our expert explained there is a very wide range of kinds of sex work. Outdoor sex work is very different from indoor sex work. Survival sex work looks nothing like high-end escorts. So, no, these are not typical stories, but they are real-life stories, and the men who were working with Lori and Terry were charged under the laws that we talked about. Terry had agreed that none of the people in that organization that were working with her and Lori, the bosses, the drivers, or the workers, none of them could have created that lifestyle on their own. It was only by pooling all their resources, their talents, and their efforts that they could have that lifestyle that she described to her mother as being too good to be true. This episode has been longer than most, and so you won't be hearing from me again for another 3 weeks. Thank you for your curiosity, for wanting to know more about what the law says and how those laws affect real people like Terry, Diane, Carol, and Lori, and all those people who are trying to work with them. In the next session, we're going to talk about spousal support. Everything you ever wanted to know but were afraid to ask. Shannon Gunn Emery, signing off.